An important task which is done after you sign the trust is what's called funding the trust. Now, funding the trust is very important because you want to make sure that the trust will govern or control as many assets as possible after you pass away. Real property almost always goes into the trust. Financial accounts almost always go into the trust. Pretty much everything goes into the trust with the exception of what are called qualified accounts. Qualified accounts are accounts where there's some sort of tax-deferred component to it. IRAs, 401ks, 403bs, tax-deferred annuities. These types of accounts do not get transferred into the trust. This is due to the fact that if the account is transferred to the name of the trust, the IRS considers that a complete withdrawal and therefore all income taxes due on the amounts that are transferred into the trust. So you may be thinking, well, how do these assets avoid probate? These types of assets avoid probate by means of a beneficiary designation. If you're married, your spouse is almost always the primary beneficiary here in California. If your spouse is not the primary beneficiary, or you want to name somebody other than your spouse as a primary beneficiary, you must get your spouse's consent in writing before the financial institution will change that beneficiary designation. The secondary beneficiary can be kids, can be anybody else, could be a charity if you want. But you always want at least a primary beneficiary and a secondary beneficiary on those types of tax-deferred accounts. Other types of assets that don't go into a trust usually are life insurance policies. Life insurance policies are usually owned by the individual. However, the trust could be named as a beneficiary. If you would like those assets to be, that death benefit, to be put into the trust or to be distributed pursuant to the terms of the trust, you could indicate the trust as the beneficiary, and therefore once you pass away, the trustee would submit your death certificate to the life insurance company, and the death benefit would be paid to the trust. The monies would be deposited into the trust bank account and distributed according to its terms. If your children are the named beneficiaries of your trust, you may want to just name the children directly as the contingent or secondary beneficiaries if you're married, or the primary beneficiaries if you're not married. The reason being is that the kids will get the money quicker if they're named directly as beneficiaries, because then the kids only have to give the death certificate to the life insurance company, and the life insurance company within 30 days has to make the death benefit payable to the named beneficiaries. So they will get the money quicker, and they will be able to utilize the money faster than if the money flows through the trust. Now, sometimes people will have strings attached to certain beneficiaries' designations within the trust, and if that's the case and you want those strings to be attached to the life insurance death benefit, then you'd have to name the trust as the beneficiary, because a life insurance company is not going to allow for intricate or very difficult distributions to occur by means of just a beneficiary designation. You'd really have to have that money flow through the trust. In funding the trust, we prepare all the documentation for you to fund your trust. However, it is the client's responsibility to make sure that the assets actually get funded into the trust. What does this mean? This means that you will need to take the deed to the county recorder to have the deed recorded, transferring the asset into the trust. You will need to go to your financial institution, take your binder with you, and be sure that the accounts get transferred into the name of the trust. We don't do that for you. We prepare the documentation for you, but it is your responsibility to make sure that those documents get to the appropriate parties and that your assets get transferred into the trust. It is very important that the assets be transferred into the trust. Where clients usually make a mistake is we prepare a beautiful estate plan, transfer all the assets into the trust, and then sometimes subsequent to the signing of the trust, they purchase another piece of property, open up another bank account, whatever the asset may be, and they forget to take title in the name of the trust. They then pass away, the asset's not titled in the name of the trust, and then we have to go through a probate proceeding. This is what we're trying to avoid with this type of estate plan. So you want to be sure that after the documents are signed, that your trust is funded. Very, very important. I cannot overstate the importance of funding the trust correctly.